Welcome to another episode of the Capital Playbook. Thank you so much for being with us. My name is Charles Williams. I am the owner and managing member of Pioneer Realty Capital. And today we're going to talk about something that if you are in commercial real estate, you really want to know. We're going to talk about the legal side, and we brought in a legal expert, Mr. Michael Farah of the Farah Law Group. How you doing, Michael?
Pretty good, Charles. How are you?
I'm doing fantastic.
Excellent.
But before we get into our discussion, as always, we have a couple of housekeeping things we want to take care of. If you're watching us on Apple, Spotify, YouTube, please do us a favor and subscribe to our channel, and be sure and like this episode, and make sure that you tell all your friends about us. And that way we can continue to bring in talent that allow us to educate individuals who are interested in commercial real estate on how to put a deal together, how to play the game, and how to win. So today, this is an important episode because of the fact that a lot of times people get in trouble because they don't have legal representation. So we'll discuss the importance of that and how it works with regards to commercial real estate. And again, we're so happy to have Michael here with us. He's our expert, and so we're going to get into this discussion. But before we do, Michael, tell us a little bit about yourself, your background. Yeah. How did you get into law and start your own law firm?
Yeah, well, I've been out on my own for 12 years now. I graduated in 2009, and I've all we do is real estate transaction law. So I got into real estate law in particular. I grew up with, my family had rental properties. My dad taught me everything about the real estate business, everything from construction to buying to doing it right. When I got out of law school in 2009, it was sort of the Great Recession. It was a good time to expand, so we did a lot of stuff on our own. And I figured, I was doing a lot of different legal work at that time, doing this and that. And I said, really, all I really like is real estate. That's what I know. That's what I love. And so, long time ago, I said, I'm only doing real estate transactions because I have a realistic kind of approach on that. It's what I've done, and it's what I like to consult clients on. So we have a very narrow practice. We do real estate transactions. We have a few attorneys that work with us, and even after the transaction's done, we kind of do a lot of housekeeping stuff and make sure people run their properties right, and try to prevent problems from happening or solve them after they're already there. Okay,
well, that sounds good. So, just based on your comments, it becomes very clear to me and obvious that any attorney is not necessarily suited for a real estate transaction.
Right. That is 100% right.
Okay.
Yes.
Because there are certain nuances that are associated with real estate, more particularly commercial real estate, that, a general attorney may not have that experience or even knowledge about.
That's right. I tell you that I'm a real estate transaction lawyer, and when people call me with something that deviates a little bit from it, I send it off.
Right.
We're all good at what we're good at, and I know what I don't know. So, having a general practice, let's call it a general practice attorney, trying to do a commercial real estate transaction, negotiate terms that they may not be familiar with, that are not industry standard, that are things weird to ask for, it becomes really difficult to move a deal along. Attorneys in the commercial real estate field unfortunately have become known as deal killers, because they like to try to, ink things up too much and put too much red tape on it. But I don't do that. My job is to educate clients and to let them make their own, decisions on the risk that they're willing to take.
Okay.
I'm not a guy that likes to kill deals. I am a transactional real estate lawyer, and I don't do anything else other than that.
Okay, well, very good.
Yeah.
So help me understand, why do you think, based on your experience and expertise, why do you think it's important for someone involved in a commercial real estate transaction to engage the services of a qualified attorney from the beginning?
Well, what we try to do is prevent problems from happening early on, and we kind of do that at the very time when they decide they're going to be buying a piece of property.
Okay.
So the typical way that kind of goes is somebody calls me and they say, hey, I've got a property under contract, or I'm looking at going under contract on a property, and we start at that time with a contract. So what's the agreement between you and the buyer, or you and the seller, depending on who we're representing. And we go, all right, let's make sure that this deal is going to happen like you think. Mm-hmm. Let's make sure that this is going to be successful from the beginning, that the timing's right, that the pricing's right, that the contingencies are correct, that the little terms are negotiated. And so we try to get that on early in the contract. Once I'm in on that contract, we negotiate it. Hopefully it goes through. And then we're kind of in the deal. Escrow's opened, and we start that second process. And normally kind of have a 3-step process towards a typical deal. So contract, in contract, and then kind of closing process. Okay.
So now, no doubt you've seen individuals probably in the, just your experience get into a transaction without engaging the services of an attorney. What are some of the bad things that can happen? Well, does it always turn out good? If you go in, I'm going to save a couple of dollars. I'm going to go and lawdepot.com and download a contract, and I'm going to, this is going to be my deal. What are some of the pitfalls that can occur?
Well, I've never seen those deals turn out good, right. And that's not a self pitch. And I tell people, call me or call anybody else for yourself.
Right.
It's a relatively small amount of money to pay. On some deals, I laugh at people sometimes because they're buying $1 million or $2 million, multi-million-dollar property, and I say, "Oh yeah, it's going to be $1,000 or $2,000 or however much it's going to be to look at." They go, "Oh, that's a lot." I said, "Well, relative to the size of your deal, it's pretty small." But what I always tell people is that every little piece of advice that I give is because I've seen something happen.
Right.
I've seen something go bad.
Right.
I've seen people, for example, not review a survey, and then guess what? There's an easement going right across it.
Yeah.
I mean, I've seen people not review, deed restrictions, and they can't do what they anticipated doing with the building. I've seen people lose a lot of earnest money, on a deal that they couldn't close.
Can't close, right?
I've seen people, have to pay cash for something if they couldn't get financing or whatever it may be.
Or end up in litigation.
Yeah.
It's amazing to me. There are people out there that believe that they can sign a contract and then come up with a frivolous way of getting out of that contract and not be sued.
I get those calls all the time. They go, "Hey, I'm in contract and I want to get out." And I go, "Okay, well, it's a legally binding document."
Exactly.
And we need to see what's going to happen from here because, some of these real estate contracts may be 40, 50 pages long,
right.
And every word means something.
Exactly.
They're not there just to fill the space on a piece of paper. And what I think the benefit here is that whether you're the buyer or the seller, whomever we represent in the transaction, what we're trying to do is sort of level the playing field with the other parties, with the lenders, with the banks, with the title companies, and bring some of our experience to help them through the transaction.
Yeah, and you mentioned something when we were talking earlier that I think is very important. Even if the contract's written fairly, there may be things in the contract that your client who you're representing may not understand.
Oh, 100%. Yeah. I'm a risk taker. I'm a real estate guy. I'm a real estate investor myself. I probably take more risk than most people in this arena. And that's fine when I have clients that come to me and they want to take risk, but they just have to understand the risk they're taking.
Exactly.
And a lot of times that's a very simple part of my job is I go through it and I just explain the contract. And I go, let me tell you what this little paragraph says. Let me tell you what this paragraph says in a kind of a boiled down fashion. And they go, okay, I understand I could lose this. I understand this could happen. I understand this could happen. And then I go, and now you make that decision.
Right.
And sometimes I tell people, this is not a deal I would do. I'd walk away. Or I say, jump on it. Take this risk.
Right.
Do it. You're getting a good deal here. And it's not necessarily a financial analysis that I do. I look at the entire deal as a structure.
Right.
I put my real estate guy hat on. I put my lawyer hat on. I put my negotiator hat on. And we try to push it through.
Okay, very good. So let's just talk about a typical transaction. I'm looking at putting a property under contract. I go on to Google and I say best commercial real estate attorney in town, and your name comes up,
sure.
right?
Yeah, it probably will.
It probably will. I call you up and say, got this deal, thinking about putting it under contract. Walk me through the steps, the services that I'm going to need from you so that I can have the most predictable, successful outcome.
Yeah. So the very first thing I do is I try to get everybody on board, everybody that's involved in transaction. My client, whether it's the buyer, the seller, the broker, and everybody that's involved with it.
Okay.
And I try to get everybody on the same page. And, I love working with clients that have brokers because they've kind of done some of the education that I don't have to do already. However, by the same token, we have to dial them in, right? Because the broker's job is to close the deal.
That's how he gets paid.
That's how he gets paid.
Right.
Now, I don't have a dog in that fight. I don't really care if it closes or not.
Right.
I'm looking out for the best interest of the client.
Right.
And so I have to kind of reel them in sometimes because a lot of times some of the advice that the brokers may be given to the client may not serve them the best. So sometimes we need to put caveats in there and once again try to level that playing field. So I'll get in on the deal. I'll look at that contract and I will make some notes and talk through it with the other parties and try to come to an agreement. Go, okay, hey, can we change this or that? All right, let's do those, and then let's move forward with the contract.
Right.
But that's where it all begins: is reviewing that contract, reviewing that agreement, talking with the brokers, and try to get the deal moving along.
Okay, very good. So now that's on the contract side. Yep. Now, generally, there are other agreements that need to be negotiated or at least need to be discussed as you go through the process.
Sure.
So what are some of the other services throughout this process that you're going to provide that client, me as a client?
Yeah. So typically the second step is you're going to kind of be in your due diligence phase, right? So at that point, you're going to be looking at, for example, everything that the title company gives you. They're going to give you a title commitment. They're going to give you a survey. Those need to be reviewed to figure out what you intend to do with the property, make sure it's okay to do. You're probably going to be doing inspections on the property.
Right.
We need to make sure that those turn out right. There may be leases that are on the property, right? If you're buying a property that has a tenant in it or has an occupant in it, we need to see what you're biting off. Are you buying a property with a guy that has a right to renew his lease for another 35 years? Oops, that's going to be a problem.
Yeah.
Are you buying a property with somebody that hasn't paid rent in a year? That's going to be a problem. There's issues that can come up with that. I mentioned earlier the survey, and the title commitment, and those are two things that I see brokers fail to educate their clients on most of the time.
Right.
Surveys are a very important item. Almost always there's an encroachment, there's a boundary line off, there's something going on with it. And it doesn't take me long to sit down with the client and go, okay, here's the building, here's the land, here's what we're doing here. Let me show you what the issues are presented and make sure that these don't, conflict with what your plans are. Same thing with a title commitment.
Right.
It's perhaps one of the most important parts of a transaction. So that's the second phase is due diligence, reviewing documents, and making sure what you contracted for is actually what you want to buy. That's sort of the whole second phase of what I do. And making sure that they know what they're about to close on before we get to that third step.
Yeah, and I've seen some horror stories just from the financing perspective. Clients going in to purchase retail properties where you have to deal with estoppels and SNDAs, and of course, in order to transact the financial side of that, the tenants there have to agree to sign those SNDAs or estoppels.
Yeah.
But if you didn't put it in the lease,
absolutely,
that they're required to do it, and they refuse to do it,
we're fighting.
It could just destroy your whole deal.
I see that happen a lot. It's inevitably. I represent a buyer. I represent a lot of buyers, and I'll represent a buyer with a seller that's just doesn't have anything in order.
Right.
So we're having to fight that because they've just kept it in a mess. Or worse, you had to represent a buyer with a very sophisticated seller.
Right.
And then once again, this is leveling the playing field because they may have their own huge legal team. They may have big corporate leases that we're dealing with, that sort of thing. So, if you see some large corporation leases, I can tell you those are typically drafted for those tenants' benefits,
right?
And you're going to have to inherit that liability.
Yeah.
So and then we kind of move into the financing part, which that's your role.
Yeah, that's our role, right?
And I'll be typically reviewing those documents and making sure that the client knows
how much I'm really charging them, right?
How much you're really charging.
No, exactly. But this is an important point, and I want to make because I just see this from the financing perspective. one that I run into a lot, and that have killed deals, cost people earnest money, and really it's just terrible. When you're engaged in certain types of assets, like a retail, anything that's investment property, there are certain legal documents that, from a financing perspective, we're going to need in order to protect our interest in that deal. Those SNDAs, those non-subordinate, subordinate non-disturbance agreements.
Correct.
Yeah. Those estoppel agreements. And you mentioned those large corporate tenants. So if you go in and you negotiate that I'm going to close in 60 days, but you have, a big Target is one of the tenants.
Sure.
Okay. You're probably not going to get an SNDA or estoppel agreement from Target in 60 days that's going to allow you to close that deal.
Yeah, because I'm going to send it over to their counsel, and they're going to go, okay, yeah, I'll get back with you in 2 weeks.
Exactly.
And I'm going to go, okay.
That's after Christmas.
Right, yeah.
And it's September, right?
And it always happens at this time of the year. We're as busy as ever because people are trying to get deals done for the end of the year, 1031 stuff, what have you. But yeah, it can be a fight sometimes, and so that's why we got to make that contract right, because it's got to say something like, unless we don't get the estoppels back,
exactly,
or unless we don't get this back from the seller,
right?
But yeah, depending on the type of deal, and it may be a retail thing that we're looking at, and we want records of the financial records of the tenants to make sure that they're qualified. I mean, it may be a land deal, and we may be waiting on mineral leases or a conversation with an operator or something. It just varies depending on what it is. Apartment complexes, right now we're looking at what the insurance claims were like. Did they have hail damage on the roof that may affect your ability to finance the property or get insurance on the property later on? So there's a lot of things that can come up, and one thing I've noticed, Charles, lately is that we've got so many out-of-state buyers coming in. Lots of Californians, lots of New Yorkers that I'm working with that see Texas as the hotbed that it is.
Right.
And so it's a little education on that side, because I have to then bring them, here's how Texas works, here's how our market works, and here's how properties work. So it's an educational experience, but it's one that I enjoy.
Absolutely. So we talked about the legal guidance during the transaction, getting the contracts and so forth. Now, from a lending perspective, we're going to provide some other legal agreements, like a loan agreement, a promissory note, security agreement. There are some legal documents that are binding that we're going to issue. Why is it important to have an attorney review those? And just because a lender sends an agreement, are those terms final, or can an attorney help negotiate some of those terms?
We can absolutely help negotiate. What I typically do is, by the time they've gotten to me, they've already talked to their lender and gone over some of the high-level terms, maybe the interest rate and the length, and maybe some prepayment penalties and stuff like that, the high-level stuff. But what I'm going to do is I'm going to get into the nitty-gritty.
What happens when things go bad?
What happens when things go bad? What happens when they accelerate it? What happens if they don't renew it?
Right.
The worst-case scenario is, you get a balloon that you don't have the money for, right? And you didn't anticipate it for this, that, or the other.
Right.
Or you can't do something to satisfy your lender.
Right.
And, it's a relationship between borrowers and lenders. And if it's a new one, we need to make sure it gets started off on the right foot. But, by all means, I'll be reviewing every single one of those.
Right.
And I'll go, hey, look at this prepayment. Look at how they worded this. I don't understand what this means.
Right.
Or we need to redraft it a little bit. And then I'll get with the client and go, here's what I'm going to suggest, and I think this is fair. Let's go back to the lender. Let's go back to whomever we negotiated this deal with and figure out if we can get this in there. Once again, this is nothing that the brokers are going to be doing.
Right, because they're interested in getting paid.
Go, sign it as is.
Hey, man, just sign that thing.
Yeah.
Right.
But no, I have an obligation to the client to make sure that they understand. And it may be one of these things where they go, right now I'm getting people with very short-term financing, very, very, very hard money. And I tell them I wouldn't do it.
Yeah.
Or if I did it, here's how it's going to be. So I want to make sure that they understand what they're biting off.
Absolutely. And, it's so important. And if you watch our show on a regular basis, I talk all the time about that the buyers, they go into deals and they're only looking at the interest rate. They're only thinking about all the things, under the best case scenario.
Yeah.
Well, 90% of the time, things don't always go exactly as you plan.
Right.
And those 10% where it does, they are extremely lucky.
Yeah.
Right.
Yes.
But most of the time it does not. So you want to understand what the consequences are on the other side of the dime.
Absolutely.
When things go bad. And I've seen borrowers come to us in a distressed state because their balloon has come due, and there were no provisions made in the documents that would give them time to resolve that issue.
Correct.
That balloon comes due, that property's valuable, right? And there's nothing wrong. They made all the loan payments. Now the bank, or if it's a private lender, the private lender gets to own your property.
It's a tricky thing, whether it's a bank or a private lender. A lot of clients, they've come to me and they have, loan docs drawn up because that's their friend, this is their banker, this is the person that they've gone with. Well, guess what? Here in 2, 3, 4, 5 years, that person may not be there anymore. Right. And then guess who you're going to be talking to? You're going to be talking to whomever inherited your file,
right? And
is going to be looking at the black letter law that's in that contract.
Exactly.
And they're going to enforce it strictly. So just plan on the person behind the scenes not being there anymore, and let's just rely on the documents.
Right.
Once again, they're there for a reason. Right. If every deal went good, we would do it on a handshake.
Right.
But they don't, and that's why that's why
you have a whole legal system.
That's why I'm here.
Yeah, yeah, well, that makes sense. And again, as I mentioned earlier in our conversation, it just blows my mind that there are people that think they can sign legally binding documents and not adhere to it.
Yeah,
it just I mean, have you come across people like that before?
Yeah, I mean, I've come across, I deal with a lot of earnest money disputes, right? And that's when, after the deal's already gone bad, and then people go, well,
I want my money back.
$100,000 of earnest money or whatever it may be that's on the chopping block. And they go, well, how can I get out of it? And I'm like, well, listen, I'm pretty clever, but I'm also not a miracle worker.
Right.
We have to look at the document and see what you did. And a lot of times, the very first place I look in the document is the default paragraph.
Right.
I go right to it because does it have a cure period?
Right.
What happens?
Right.
How long is it going to be? And what can you do about it?
Right.
But yeah, the earnest money dispute is a really good one because it's what people see a lot of times when deals don't go well.
Right.
And when they fall through before closing.
Yeah. Yeah. That's terrible.
Yeah.
So now we've talked about the importance of having legal representation throughout the transaction and the various stages where you need it. I don't know if we talked a little bit about closing, through the title company, make sure you get a good title policy. Now, and we've talked about what happens when people fail to engage legal counsel. What are some of the success stories? Where you come in, you fly out of the scene looking like Superman.
Yeah.
What are some of those?
Well, a lot of times those success stories are typically when simple documents were just omitted due to no fault of anybody's, but maybe just clerical oversight. And, I've had several cases before where somebody's buying a property with existing tenants in there, an existing tenant base. And, for example, one of the things they forget to do is assign the leases, right? Because that lease is in the former owner's name.
Right.
You as a buyer, you're going to inherit them. Well, you need to legally inherit them.
Right.
Those need to be legally assigned to you and now make those your property. They may or may not require, some kind of consent from the tenants. Mm-hmm. But it was a case that I had, and they were at closing, and that's when they engaged me, and I started looking at their closing documents, and I go, well, you have leases, right? Yeah. Okay. Where's the assignment of those to you? And they go, well, we don't have that. Right. Well, the thing was, we had an out-of-state seller. Trying to track that stuff down after the fact, it would have been just a nightmare. But I mean, something so simple, it's a 1 or 2 page document that I'm able to go, did you have this? And it saves a big headache. You know? Or just reviewing a settlement statement. A lot of people, especially if they're not doing this every day, they don't look at settlement statements.
Right.
Title companies most of the time are great, but there's also humans, and everybody makes mistakes. So sometimes there may be something on the wrong line, and maybe the earnest money was on the wrong line, or title policy is paid by the wrong party. So little things like that, it normally pays for ourselves.
Right.
And that's what I try to bring to the table. I want to bring some value there to go, our cost is really pretty minimal when you
Well, it makes sense.
Down.
I mean, I've seen some crazy stuff in my experience. As you go through, as an example, I'm going to ask you a couple questions. The typical all-in cost, just in general, from engagement all the way through loan documents through closing, if you're reviewing everything, is.
The answer to every legal question?
It depends.
Right.
Okay, but just give me a high, because I'm really helping my audience appreciate the value. Because I'm going to compare it to what litigation costs.
Oh, yeah.
Right?
I would say on the low end, and typically we charge hourly, so I would say on the low end, you're looking at a couple $1,000. Depending on the size of the deal, on the higher end, maybe 10.
Okay, now that we have that established, what does it cost to litigate a dispute?
Good luck on just getting a $10,000 retainer.
Right.
To start.
Right.
Once you're in the court system, the ball is out of your control.
Absolutely.
You have no control whatsoever. And I'm not a litigator. We throw all of our litigations out. But I can tell you, litigation is an absolute nightmare. And what I normally talk to people about that process is I go, well, have you been in a lawsuit before? No. Okay, well, buckle up.
Yes, sir.
You're ready for a ride because this is going to be very expensive.
And take a long time.
And the unfortunate thing about litigation and the judicial system as a whole is he who has the money makes the rules.
I will just absolutely tell you that. If you, unless you have a lot of money to burn in risk, because you can be right, okay?
Yeah.
Right?
Uh-huh.
You could be absolutely right and absolutely lose your case and a lot of money and get to pay for all your legal expenses and all the legal expenses of the opposing counsel.
I had a very astute client. We were in a large transaction, and afterwards he thought that something wasn't quite right. And he said, well, should we think about litigation? And I said, this is kind of what you're looking at. And we kind of came to the understanding, which is, hey, if it was less than $1 million, it's probably not even worth it. Think about it,
right?
Because on a real case to get all the way through it, there's a lot of money that goes into litigation.
Absolutely.
So people come to me with $5,000, $10,000, $20,000 disputes. I'm like, it's not even.
You better
maybe go to the justice of the peace yourself,
right.
Because it's not. You're not going to be able to get counsel in for that.
Absolutely, and we don't. If we've been in business 19 years, so we've seen things litigated.
Yeah.
And I can tell you for a fact, I haven't ever seen a case that was resolved through litigation less than $150,000.
Yeah.
I've never seen it in 19 years. So just based on that, the services of a qualified transactional attorney can save a person a lot of money.
Oh yeah. Yeah, absolutely. And like I said, if it's me, if it's not me, I give out so many referrals. I was joking with you earlier. I refer out a lot of cases. I mean, we take on what we know, but even if it's in a different county that we're not always practicing in, I'll send it out.
Yeah, that's a very good point. Tell me why that's important. And a lot of people don't understand, even on the litigation side or just in transactional law. Knowing the lay of the land and knowing the parties involved, you got to know the judges, you got to know the court system. Why is that so important?
Oh yeah, it's critically important. The 3 L's of real estate: location, location, location.
Right.
And I'm a somewhat of a location expert here in Tarrant County. I mean, you could probably tell me a neighborhood or a street, and I may know it. Dallas County, I'm pretty good in, but when we start going deep out, I don't know what the particulars are of that county.
Right.
I'll give you a quick example. I had a guy bring a contract to me the other day, and he said, hey, this is some land that's zoned for a mobile home park in Earnest, Texas. And I go, it's zoned for it? Is anything built on it? He said, no. He said, I want to build it. And I go, good luck.
That's not going to happen.
The likelihood, I don't care what the zoning says, the likelihood of you pushing through some project like that in the city that I know,
right,
Earnest, Texas, they don't want it.
Right.
And I said, I wouldn't pick that battle because I know the particulars of the locality. And it's an uphill battle, and sometimes we look at that with clients and they go, well, we can do this or do this and we can ask for that. And I go, yeah, but you're going to be fighting. It's going
Right.
to be a fight for you.
Right.
Do you want to fight or do you want something easy?
Right.
And it may be dealing with community associations. It may be dealing with planning and zoning or city council.
City
or whatever.
council. People with no money in the deal, but they have big ideas.
Yes,
right?
yes.
And they will kill your deal.
Yes.
So,
I mean, sometimes that's what they want me to do is they want to hire me and go talk to certain people and go, hey, can we do this or can we do that?
Right.
Talking to neighbors, making sure what you want to do is feasible.
Right.
I mean, that's what a lot of big developers do before they get deep into a deal with $100 million. Hey, go talk to the church next door.
Right.
Go talk to the local lady and make sure that you're on the same page. You don't want to fight.
Right.
Ideally.
Right.
So.
And again, saves a lot of money.
Yeah.
Yeah. So I'll tell you what, this has been phenomenal, great information. I really hope that you and our audience really appreciate this. This is inside information. This is part of the Capital Playbook, the playbook that teaches you how to win at this game called commercial real estate. Michael, thank you so much.
Thank you, Charles.
Michael Farah,
Appreciate
the Farah
it,
Law Group.
Thank you.
If you need him, call him, look him up. We'll have his information on here. But absolutely continue to subscribe. Make sure you like this episode. That way we can bring you content that benefits you in this commercial real estate game. This is the Capital Playbook. Join us next time.